Okay, so we're here tonight. We're going to talk about family court, and we're going to talk about a pretty egregious case out of Idaho. And I'm going to bring on two guests that we have tonight. We have Sarah, who's a protective mom from Idaho. We also have Jill Jones Soderman, who is the executive director and founder of the Foundation for the Child Victims of the Family Courts. And we're going to talk about this pretty egregious case in Idaho. And Sarah, I think you're facing a contempt hearing. You and your attorney, she's an attorney in your federal case, which is a former attorney in the state case or the family court case, tomorrow. And we're going to talk about that right now. So, Sarah, why don't you tell us, how did we get here? How is it that you are a protective mom and you're facing contempt? What's going on?
I know. Well, I first will tell you it took me a while to kind of figure out, when it first happened, I just didn't know. So basically, I had raised children with my children's dad, and he started drinking, getting blackout drunk, and enough stuff had happened. He basically had said he was going to get rid of me and my teenager and take my two children, and his mom would help him raise my kids. And so obviously I started getting more and more worried as time went on. And I had my son during the pandemic. So then I had three children and my son's special needs, and so I just couldn't get help anywhere I called. Pretty much it was just like, you can go to a homeless shelter. I just didn't know what to do. And by then he would say, please, I want to figure it out.
We'll start this for you. There was a point where you had your children and then they were removed, right? Your children
were removed. The thing is I went and got a protection order from Faces of Hope, and I told them that he had been threatening to steal my children and I needed a custody order. I didn't feel very safe. And they came to Canyon County and removed him from the house. And while that was in place, he committed a felony. I was asleep. And
wait, let's break that down. Let's break that down. So you have your children, you have custody of your children, you're protecting your children, and you have the children's father who has a criminal background, a violent history, abusing alcohol, right? And there's a whole bunch of other problems going on, committing crimes.
He was taking kratom and shooting up testosterone and steroids, and then also taking prescribed amphetamines. And then he has some mental health and previous addiction. So, of course, this started coming out after I was involved with him. It started kind of coming back. And
but in a situation
that's why I got the protection order.
You get a protection order. You feel so unsafe with your children that you need to get a protection order to protect them from this man. And yet, when it gets into the court, how does it end up that the court awards custody to the abuser? Tell us how this happened from your perspective.
Well, I thought at first that it was a mistake because he had committed the felony while the protection order was in place. And then he begged to keep our family together and come home. And so I let him come home and do probation and classes. And towards the end of his probation, I started seeing him veer off. He was staying out. I found alcohol in the garage. Number of violent things had happened, and he had started making the threats again. But he'd also said, I'm getting ready to get off probation. So I knew that was coming, and I started calling Faces of Hope again, saying, hey, I think that I'm in trouble, that my children's dad has been kind of going back to the same thing and he's getting ready to get off probation. And by then his family was involved and they found this avenue, which was they called CPS. My son's autistic and he had bumped his head on one day. I was driving him to school and he was unregulated, and we were driving past a flamingo store, and I thought it was just over the flamingos, but his tablet had died, and he bumped his head on something, and I had to pull over. I was going 55 miles an hour, and I pull over and put him back in his car seat and get him kind of calmed down. And I realize he's got a little owie right here, just tiny, barely bleeding. And I mean, plus I was upset. This is so scary when your child is going through this, and all of us had endured this experience with Diego getting out of his car seat, smashing. He was a headbanger, and all of this. In fact, I had seen his doctor 3 weeks before this happened because I was trying to get a special needs car seat.
Your son had a mark, and that was used as a pretext to remove the children. You said there was no warrant, there was no hearing. How did that happen? Tell us about that.
Well, I think so the dad, I didn't know, but he had met someone, and so he utilized the school, the autism. It's actually not a school; it's an ABA center, which I'd highly recommend parents avoid those privatized places, because I had my son there and they did a mandatory report. Well, it was from my children's dad calling them or somehow expressing his concern for me. I mean, so
you're saying
sure
that
how it all happened.
They weaponized a mandatory reporter to file a false report or a misleading report.
Yeah, and I was called in 3 times.
But tell me about this. Now, of course, they can file reports, but then does this end up at the family court? Was there due process? What happened next with respect to
no. So what happened was, and I mean, first when they'd come into the house, I mean, I let them right in. I was like, oh, come on in, because my son's autistic, and I have a case manager for his disability. So I was like, all about child safety. I brought him in, and then they started threatening I just started seeing it go bad. They started threatening my daughter, my teenager. Dad asked to leave. He said he had plans. And then they came back a second time and they said I'd been called in again. So, I mean, that's when I knew, yes, it was being utilized, that somehow I was a negligent mom and my son had this little ouch. But even then I was like, well, this isn't something serious. And then they said
this is CPS that did home visits and your interaction with CPS. Eventually this ended up with the guardian ad litem and the guardian ad litem's report. Is that correct?
Well, yeah. So what the dad did, actually, this is really weird. They put me on a safety plan and the dad refused to come home, which it was his house and our house we'd raised our children in. And so they let him take my sleeping children out of the house with his mother. And then they went and filed a protection order. And I never talked to health and welfare again. And I never talked to my children again after that.
All right, I'm gonna pause here for a second, and I have Jill Jones Soderman, who's the executive director and the founder of the Foundation for the Child Victims of the Family Court. And Jill, you've been doing this for a long time. Tell us how familiar of a story this is with the CPS and this type of activity coming in, and then in the dark of the night. First, they have a hostile type, a couple of reports, and then something like this happens. Have you seen this story before?
This is a uniform pattern in which the transfer of funds from the federal court to the states is implemented by any charge against that they can find, that they can locate against a parent to establish cause for abuse or neglect.
So you're saying that the CPS is motivated to find problems?
Motivated, integrated, integral into the pattern of transferring children from a parent into either the CPS system for then termination of parental rights, and then picking up on the adoption process, which will allow funds to be established for accrediting foster and then adoption homes. And they can go through 6 or 7 adoptions, get $50,000 a piece for each adoption evaluation.
So for everybody that's watching that may not know about this, Jill, tell us about Title IV, and tell us about the Violence Against Women Act. Tell us about these. You're alluding to federal funding
Right.
that is available that supplements the state family court budgets
Right.
and that funds CPS. And
Right.
so for them to justify their existence at CPS, they have to find reasons to separate children from protective parents. Is that what you're trying to say?
Exactly.
And I heard with the autism too that it's the incentives are even higher, and that's where I started knowing something was wrong, because I started getting that motherly feeling. I mean, they were trying to take my children. So not only was I dealing with like an abuser that was doing that, but they themselves, and they didn't check my children's dad's record or anything. And so I knew they were not really looking for like the safety of my kids. They weren't checking that all out. Clearly.
Right.
I mean,
well, let's talk
You're
about that real
totally-
quick. Let's talk about that, Sarah. You've
Sure.
alleged that your children were placed with the dangerous parent. What
Yeah.
evidence supports that claim?
well, I mean, just that he had $100,000 bond, and a huge record, including trafficking heroin. And I just knew, like, anyone that was trying to be safe for my kids, they would have looked at
You
like
have
a little
court,
more
wait,
than the
stop a
felony
second.
domestic violence.
Stop a second. Whoa. You have a
Yeah.
court-appointed guardian ad litem. You have CPS, and they're recommending that your children be placed with the person who has a heroin trafficking history,
Yes.
that has a $100,000 bond, that has all this criminal stuff. Is that what you're saying? That's what's the facts of your case.
Yeah. So the guardian ad litem, I couldn't get that until my attorney helped me. I mean, they were trying to deny me. I mean, my kids had no one for 8.5 months. I had no idea what was happening with my children. I begged for an attorney for my kids for 8.5 months. I was denied on 9 motions.
So this was,
and then the judge recused himself.
Stop for a second. Let make it very clear for the audience. Did
Sure.
a judge sign an order handing your children over to the abuser, or did CPS just do it on their own, or what happened?
The judge did. He ordered a 30-day investigation, and
which judge was this?
Goldstrom.
Okay, that's the first judge. That's not the judge you have now.
And that's when, on the protection order, Fabian had, or the parent had, not disclosed his domestic violence. He filled out the protection order and attached the safety plan, and didn't disclose that he just got off probation and no one checked. And so they signed it off.
And so this was all done on a temporary order. Is that what you're saying?
Yeah.
Okay, so and for the audience, I've actually interviewed Tammy Nichols, who's the state senator from Idaho, and that's one of the things that she had hearings, and your attorney Bethany Starr Neiman was actually one of the people that testified at the hearings. I know you testified at hearings as well.
Yeah.
These temporary orders could be a real problem, because what they are called ex parte orders, where only one side walks into the court and presents their allegations that are untested, and then children are removed because judges practice defensive law. They say, you know what, if there's any claims, let's just slow everything down and make CPS get involved, and they're afraid if there are allegations put in front of them, even if they're bogus allegations, well, God forbid they're real. So, Jill, tell us a little bit about these ex parte orders and what you've seen with the family courts and the child victims.
Well, whenever there's an opportunity to move the child and to investigate and to bring in resources, that activates Title IV, aid to needy and dependent children. So it's the movement, it's the allegation and the movement. If she came in and said, I need protection from my husband, they would deny that motion. They're asking for the child to stay in place, which then does not provide services to the children. It's the movement, it's the cash flow, and it's the ability for the court to then put in a back channel bill to federal funds, to start the federal funds from Title 4D, and to defend the opposing party, the opposing parent.
So
Is
hold on, Sarah. There was clear evidence of
yeah,
domestic violence in your case, correct?
yeah, a ton of
What was
it.
the
Yeah.
evidence? What was the evidence of domestic violence?
Well, I mean, he had a domestic violence protection order and then a arrest for $100,000 bond and then probation. And he said he's a habitual domestic violent abuser, felony.
Okay, and
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 he
w-
did
and
that in the presence
and,
of our children.
and this was
It,
ignored by the court.
yeah.
Was
And,
the evidence admitted?
and
Was the evidence even admitted?
Well, I mean, where it started was
The answer is
CPS.
no. The answer is
Yeah.
no. No.
Yeah, no.
The answer is no.
They never
answer
checked.
is that if
They
you
never checked, and he lied on the thing, but they never checked. And the CPS said they don't check records, and the
not
judge
true.
said no one checked.
They will
so,
say
Jill, tell us about this. Tell us about how often this happens, where evidence isn't preserved, evidence of domestic violence especially is not presented to the courts or is ignored by the courts. Tell us
I
about
would
this.
say in this day in time, as they've perfected the process 100% of the time. And one has to know how to look and where to look to uncover the process. And uncovering the process means looking at the cash flow, knowing
Yeah.
how to go into the back channels for the grants from Title 4D and Title 4E. And those grants are written through the judge's orders. They're triggered by the judge's orders. And a bill is produced by the court, by the guardian ad litem, and on generated structures that are already in place that condemn anybody that they can target. She became a target because her child had a bruise on his head. They weren't looking for what, why, or how they could be helpful.
Yeah.
It became
Yeah.
okay. Here's our entrance into.
Okay.
You didn't have a seatbelt on. You had a gun in your possession. They look for evidence to use against you. And
Well, at first they used the car seats, and then I had car seats. They're like, "Oh, you have a bunch of car seats." I'm like, "Well, yeah, I'm getting a special needs car seat." And then they
Okay.
were like, "Oh, that was false,"
Right.
But then it was something else. Mm-hmm.
But they look through the scene, and they find anything and everything they possibly can to arrange for the transfer. You look for movement. You look for the change in the situation, and how long they can keep the child in whatever situation they're in to provide services or say they're providing services. To appoint guardian ad litems that then further punctuate the cash flow by calling in whatever support agencies, whatever experts, whatever court-appointed licensing board officials. They're Johnny One Note, and they all if their lips are moving, they're lying, and they're supporting each other.
So I want to, Jill, I want to get into the March 31st date, which is tomorrow, in Canyon County, Ohio. The judge is John Meyenhofer. He's your judge in your case, and he's already found contempt against you and against your attorney, Sarah.
Yeah.
And the situation here, and we'll get into this a little bit. This is an article that I put out a few days ago, and we have a picture of Anna Mamani, who is the attorney for the father, and we'll talk about her. But there's a big issue here, and you had filed a federal civil rights case in this or a related case in federal court, and we'll bring that up. But one of the claims that you have here is that this is an egregious issue. And the contempt is a retaliatory contempt. Here's you testifying at the Idaho hearing before the Senate and the legislature, and they're retaliating against you for speaking out. And then,
Yeah.
and in so doing, you filed a case in the federal court in Idaho. Tell us about the retaliation. Tell us what's happening.
Well, I mean, Bethany came into my case and tried to, because we thought it was a mistake or like someone had overlooked it or we had a bad judge. We couldn't really figure it out. And she really didn't want to take a family case, but she stepped in, and then her and the judge, it just started going bad. I mean, with the new judge. And I mean, I don't really know how to explain
And
it. It just got worse and worse.
This is the complaint. I put it on the screen, and it's filed in the federal district court in the District of Ohio. And basically, it talks about a retaliation. Okay, it talks about the parties in the case, and that you're in Canyon County, and that it's a civil rights violation. Okay,
Yeah.
and there were the claim here is unobtained referrals and a coerced safety plan. So that CPS, they received a referral from Opal Autism alleging an unexplained injury and a marijuana odor. Okay, and as you said before, you provided an explanation. And then law enforcement even confirmed that you didn't do anything wrong with the seat. But the problem is that wasn't good enough. They went in and they made things coercive. The father, there was the known risks of the father that all the parties knew. The criminal history. They knew the felony domestic violence, heroin trafficking, and violations of protective orders. But yet they still facilitated the placement of the children with the father, and they advised the court to obtain the protection order, and they advised them to obtain it against the plaintiff. So that was that's a big part of it. And then the false reports are another big part of it. So that's what your lawyer has here. But your lawyer is going to be standing next to you tomorrow.
I know.
In this and looking for contempt. So, do you believe that she is being targeted as a retaliation for exposing the system?
Absolutely. Well, because I mean, again, we started out with this new judge. He said this was a terrible case. We thought that we got it, where he was going to really take a look and get the custody right. And then the more and more we went on, the judge just started turning a different direction, and he was just eliminating me. He didn't just give me my kids right back. This had been all proved false clear back in March. So, I mean, now we're in July, and this judge, instead of just giving me my kids, I'm having to pretty much beg for my children still and do the family wizard. And the abuse continued in the family wizard, where he wouldn't let me see or talk to my children, and just deleted me out of the YMCA and our medical system.
So
and
this is the judge right here, 3rd District Magistrate Judge John Meyerhofer. He has been publicly reprimanded already. And he's the guy that's going to be looking to take you and Bethany. And this is Bethany, and this is for people who don't know. It's Marianne Petrie. You were on her show, and you've talked about your story. But Bethany Star Nyman is going to be facing contempt. And so I sent them some emails, as a journalist does, and asked some questions. I didn't get any responses. But I asked them about the fact that the big one, I think, is that concealed or failed to disclose material information concerning the father's domestic violence history. That's Anna Mamani, who is the attorney. They didn't bring any of this up. When you get to a family court, the standard is best interest of the children. And yet the attorney, this is the attorney for the father, Anna Mamani, does not bring up or didn't disclose or was dishonest, I think. I feel dishonest.
Well, it kind of gets deeper. I have a full police investigation where she was identified filing a declaration under oath and denying domestic violence completely. And then she continued litigating me for at least 17 more months now, even after she knew all of that. So, I mean, even if it was like a mistake or like she was trying to kind of cover it, and I had requested an ex parte custody of my children, and she blocked it and denied and said he had never committed domestic violence. And I scratched my own eye.
And yet there's a felony conviction for domestic
Yeah.
violence. And she
Yeah,
said
with
this on the record.
$100,000. Yeah.
Wow, that's out of control. Now, part and parcel to that, and we're going to get to Jill in a second about how, other parents who are facing similar situations can start to muster the evidence that's necessary. But part of it here is some of the systemic issue with the guardian ad litem. We have this guardian ad litem report, and this is probably one of the craziest reports that I've seen. But then again, I hate to say it, I see a lot of crazy guardian ad litem reports. And this thing reads like, okay, this guy's a terrible guy, but he should still have the kids.
Yeah.
And it's one of the crazier things I've ever seen in my life. Mr.
I
Ybarra's
know.
criminal history dates at least back to 2006, when Mr. Ybarra was a juvenile accused for petty theft. Again, Ybarra was convicted for petty theft in 2013, placed on probation, ordered to community service. He has 7 case numbers from 2013, including speeding, leaving the scene of an accident, probation violation, drug paraphernalia. 2014, Ybarra trespassed from Maverick Stores after conviction. Mr. Ybarra reports being married to somebody else. 2015, filed for divorce. 9-year-old daughter that moved in. Then in 9/20/22, Ybarra was charged, convicted, and sentenced to probation for felony domestic violence. They have the whole stuff from the Caldwell police, a criminal no contact order. We have this is like in the guardian ad litem's report. I don't know how an attorney could walk into the court with a straight face and not know this and argue that, oh, no, there's no domestic violence history. Oh, no, there's no violation of a no contact order. That's in black and white in the court document. And yet at the same time.
Can I tell you something?
Yeah, go ahead.
Not only that, they put a protection order against my teenage daughter, who was a victim in that felony, and disappeared her from her home and her siblings. And same thing, he lied on all of those. And then, so every time throughout this, they had so many thousands of chances to hear what I was trying to tell them, that this was not safe.
Yeah. So that's what we have here. Now I'm going to go back to Jill. Jill, how prevalent is this from what you've seen in the family courts, where we have clear indications of non-fitness of a certain parent, of abuse? Here we have a felony domestic violence prior conviction. We have a violation of a no contact order, and yet this person is still awarded custody of the children. What's going on here with the family courts?
Well, let's deal with the attorney for one thing, and the whole court process. I would say this is uniform, that this is an abuse of power in the service of collecting money through the system. Yes. But let's start with the attorneys. Why wasn't there a stay and appeal of action on the original steps? One doesn't go from family court to federal court. The case is going to be dismissed in federal court. That's not going to happen. Let's stop right there about federal court, because I think parents need to know this, and people need to know this about civil rights cases. There are two very important federal court doctrines called the Rooker-Feldman doctrine and the Younger abstention doctrine. And those legal doctrines, they do their best to try to wedge any family court case into one of them or both of them, to say that the federal courts are not a place for state matters, and a family court is a wholly state matter. So you would have to be able to say that there's no state court issues to be looked at, or they've all been exhausted. That's one of the two. And you clearly haven't exhausted the state issues, and it's not a pure case, a federal case of maybe corruption, where you're looking for declaratory and injunctive relief.
against an executive branch or even a judicial officer, because that's available. There's so strong judicial immunity.
Yeah.
You know, you cannot, Stumpy Sparkman is the famous Supreme Court case, but you can ask for declaratory and injunctive relief in very limited circumstances. But you can also go against executive branch. I think that Jill's 100% right. I think this federal case is DOA.
Ridiculous.
That being said, you talk, Jill, about lawyers as liabilities all the time. What do you think should happen with this case?
Well, there are any number of things that should happen in terms of immediate circumstances. I'm not an attorney. I'm a psychoanalyst and a forensic expert, but I work with very skilled, scholarly legal attorneys. We would never have been so stupid as to file a federal case. You start by doing an appeal. You look for an appeal process or a reconsideration and a say of action. You look for immediate remedies in terms of the immediate situations. You also look at back channel flow of money. You look at the involved the profiles of the judges and the guardian ad litem, and you look at the interdigitation of their work and their association, and you find evidence in that area of collusion, and then file. There are many things you do all at the same time. It's not one thing or another. There are actions to release the child on a habeas corpus action, on a state habeas corpus action. They're going to suppress the evidence. They are spitting in your face saying, we don't care what evidence you have. We're going to list it. We're so brazen and so secure in our position that we're going to list everything: the rape, the murders, the cutting off somebody's arm. This is what the person did, but we're going to do this anyhow because we can. Yes, judicial immunity involves acting within the scope of your authority. The abuse and the indifference to human life and suffering, the ignoring that is not within the scope. And yes, these judges can be sued, properly sued, against their immunity. And the foundation has done that. And we have gotten judges not only removed from the bench, but put in federal prison for 10-year sentences. One of them only served 5 years for good behavior.
One of the comments is actually a very good comment. They're outside the color of law, and
Right.
that's 18 USC 241. That's actually the Ku Klux Klan Acts.
Right.
That's what they filed. And so when you have this actually after the Civil War and the Reconstruction Amendments, and the 13th, 14th, and 15th Amendments, and they would go and you'd have judges and you'd have executive branch officials and all sorts of officials in the South that would ignore the fact that people weren't slaves anymore.
Right.
And so you allowed the Ku Klux Klan Act to come in. Right. And to take people under the color, or acting outside acting with the color of law to discriminate, or acting outside the scope of their powers. And so the Ku Klux Klan Act still exists as 18 USC 241, and it's happening. And I think the epidemic of this happening is in the family court. I think we still have slavery in the family courts to a large degree. I have people that say all the time it's easier to be in a criminal court because at least you have rights.
Right.
In a lot of cases.
This is child trafficking. This is the family court and everything associated with it. So any lawyer who filed this, is, in my personal non-lawyer position, knew exactly what they were doing, because they were providing shade for all of these.
So the state case is actually against individuals at Health and Welfare that did this. These individuals who did this, and so actually my lawyer,
the state actors, and they have immunity.
Well, I mean, my attorney withdrew out of my family court case and then opened that one against Health and Welfare. So
let's take a step back and talk about this real quick. Hold on a second. Let's talk about this real quick. I'm going to put something on the screen, and this is a letter that your lawyer, your current lawyer now in the federal case, and Bethany Starr-Nyman had sent to Judge Meinhofer, basically, and it was in defense of you and the characterization of your conduct, and this is the lead up to the contempt. And so talk to us about what type of ruling, what type of conduct did the court say that you were involved? The court said a few things. From my recollection, is that they said that you were, you weren't cooperative, and that you were, you were engaged in improper behavior. Tell us what the basis of the court's contempt tomorrow is.
Well, he told me to not speak, and I was trying to explain something to him, and the opposing attorney, Mamani, they've worked together for years. And so it's like, he just kind of like skips over me. And by then I don't know, it just unraveled so bad with my attorney and me and him, and no one would listen to anything. And that's just what he said, is you interrupt. He said Bethany and I were the worst litigants he's ever had, I believe, something to that manner, in 30 years.
So he basically said you were disruptive, and that was and you were speaking in his court, trying to make your position known. Jill, in your experience, does this type of thing happen where they label litigants as
constantly? It's an abuse of power. It's insulting. It's misogynistic. The courts are equal opportunity abusers. It's not simply men. It is cash flow. You are dealing with cash flow, and they're throwing whatever nonsense they can. But your attorneys have failed to provide the proper legal defenses to make a record and to establish the chain of events.
I was pro se until Bethany helped me. So that's part of it too, is it's really not Bethany. I was defending myself, and Bethany came into it. She's not worked in family law much. She worked in criminal law. She has a bar card in Idaho and Montana, and she just thought it was a mistake. She thought maybe a judge missed something, or this had to be an error. I mean, we all kind of thought there was someone overlooking it. Or
these abuses have been going on since 1983, which began with the marketing program of Dr. Richard Gardner. And that marketing program was then picked up by the bar associations across the country in terms of a focus on probable deniability.
Wait, let's get into that real quick.
Right.
That Dr. Richard Gardner came up with something called parental alienation syndrome in the 1980s. Tell us about Dr. Gardner. You actually had interaction, in your career with him and some of his acolytes. Tell us about Dr. Gardner and who he was. You've written about him extensively, and his theory. And you say that it's a debunked theory, that it's a harmful theory. Tell us why.
It's a perversion. Gardner's practice was based on the defense of men who had committed incest, but his theories involved his published theories were that children were sexual predators. They were born as sexually active individuals, which are biologically impossible, scientifically, biologically, medically impossible, and that children seek to inveigle adults, unsuspecting, naive adults, into sexual activity, and then turn on the adult to get the adult into difficulties.
So you're saying that the core of Gardner's theory is the defense of pedophiles.
Not my situation. She's talking about how this court came to be.
Right.
Okay. Yeah,
but you're saying that, I'm not talking about your case, Sarah. I'm not talking about your. I'm talking about. Wait, Jill. Wait 1 second. You're saying the core of Dr. Richard Gardner's theory in the 1980s that's been adopted in some part by family courts across the nation is the defense of pedophiles. Is that what you're saying?
It is the defense of it is Gardner's theories involved seeking to increase the birth rate of the white population and to generate sexual activity in children younger and younger so that the birth rate would go up. But the core issue that was picked up by the Bar Association was the probable deniability. Gardner said there's no sexual abuse because children are sexual predators, and that the mother who is jealous of the father and the father's interaction and contact with the child is simply promoting his paternal role to generate sexually active children. So
this has been debunked as junk science, correct?
Yes.
You know,
Yeah.
okay. So let's make that very clear that this Gardner's theories have been debunked almost universally. I'm not going to say about parental alienation. There's still a place where people can feel alienated, but the problem there is it's not a clinical term or a legal term or other things. But we're going to put that debate on the side right now because the topic here is this contempt hearing tomorrow.
Parental alienation. Let me just say, parental alienation, as per Gardner, in that definition of Gardner, is a manipulation of the law to insert the concept of probable deniability, that maybe abuse took place, maybe it didn't. It is a legal tactic. That is the problem that has been weaponized and used by the Bar Association. But in relation to doing that in winning cases, it then tripped into the whole Title 4D and child protection.
So let's bring this back to Jill. Let's bring this back to Sarah's. Jill, let's bring this back to Sarah's case.
Yes.
Now there's a situation here that raises eyebrows, and Sarah's made some rather serious allegations about perjury, fraud on the court, bias on the bench. Okay, let's break that down right now, Sarah. Tell us about these things: the perjury, the fraud, and the bias.
Let's talk about racketeering. Let's talk about racketeering. Let's talk about the connection between the judge, the police, CPS, the guardian ad litem, and every single lawyer that worked with you. I do not believe that anybody doesn't know. The Bar Association is promoting courses all the time about how to work with and weaponize the concept of parental alienation, just as they weaponize reunification therapy. It's like, if you don't like that name, we'll give it another name, another subtle. But this is a known quantity within the legal community, and there's back channel communication and back channel pay about this.
So let's talk about this in Jill. Let's talk about this in Sarah's case.
Right
now, we have this lawyer, okay, Anna Mamami, okay, and she was cozy with everybody. Tell us about the relationship that you saw, Sarah, with Mamami and some of the other court actors.
Well, I mean, the judge said they've worked together for years, but also just like common things, like she was unlocking the courtroom doors. She said,
wait, the lawyer had a key to the courtroom?
I mean, she was unlocking the doors, I would assume.
If that's not a microcosm of the whole problem, then I don't know what is.
It was very weird. I mean, she made a comment how I didn't bring water today like I usually do for you guys, or like almost like her and the clerk and the judge have known each other very well. Small talk before our court hearings. And even Bethany, actually, when she first came in, she called out my judge and Mamani and said, why don't you recuse yourself? You know, I call out an inappropriate, you know, I can't remember her exact wordings, but she had asked them then and said that, yeah, and they said no. And then I put a motion to disqualify Mamani and my judge because the perjury has been ignored by this time, like 15 months or 12 months. And I'd had 2 judges, and then I found out the judge was involved with that other girl that's raising my children's crimes, which are felony injury to a child and manufacturing methamphetamines. And I mean, it just kept getting worse and worse.
But
I don't.
you as
So-
a did a fabulous job. You did an absolutely wonderful job. And the better you did and the more you produced, the more they retaliated against you. And it was done by racketeering, by internal back channels. We're not even so much back channels, but internal communication and support.
Jill, explain this for the viewers. It's a systemic problem in the family courts. Explain the systemic problem that you've seen, and you're actually out of the frame a little bit. Move into the frame in the middle. Yeah, there we go.
I'm like leaning towards her. It is a systemic problem because of the cash flow and the judge's capacity to appoint guardian ad litem lawyers to begin the cash flow of funds from Title 4D and Title 4E and other services. And if you look into the back channel of the business connection, who's on each other's boards, back channel real estate, short sales, the list is endless, but you have to be able to know how to research and how to dig into the personal histories and connections of each of these people. And it's free floating evidence. It's out there.
So on that note, I did ask my judge on the record if he had money motivation in my case. And I mean, I said it like, I really nicely, I was just like, I can't, I'm sorry. I just have to ask you this question,
You slit your own throat in doing that.
Yeah, so pretty much.
You were absolutely correct. You were absolutely correct. And the answer is yes, there is. And he demonstrated it to you by just tearing you limb from limb.
Well, I was going to say he smiled at me, cracked a smile. And in the next hearing, he actually told me I could make any complaint or tell anyone and it wouldn't matter.
Are there transcripts of the hearings? Do you have transcripts? Right.
Yep, I have all of it now.
So why was there an appeal? Why didn't anyone take the step?
First, the next step is this tomorrow's
contempt. I'm not there yet. I'm not to an appeal yet.
Yeah. The next step is tomorrow's contempt hearing. So what are you expecting tomorrow at this contempt hearing,
That she's
Sarah?
going to go to jail. That's what's going to happen.
What do you think?
She's going to go to jail.
No, I'm asking Sarah. Sarah, tell us what you think about what your plan for tomorrow.
Well, I mean, I was hoping that I can just, I have said I have no contempt against the court. I have apologized. I mean, I'm hoping.
You have nothing to apologize for. You have nothing to apologize for.
I know, but that's pretty much what I'm assuming. The real concern I have is Bethany, my attorney. She's probably not going to apologize because she knows what's happened to me and my kids. And
I'm not going to go to jail. You are.
Yeah.
I mean, I can tell you what you need to do. And you need to ask for a continuance.
Yeah.
You need to ask for a continuance. You're going to fire counsel, and you need to ask.
I don't have any counsel.
Well, then you need to.
Don't they have a public defender they're giving you because they're going to potentially take away your liberty interest?
So that brings even a better.
Well, she'll just call it.
Well, Jill, wait a second. You're required under law, if it's a criminal contempt or a contempt where your liberty is at stake, you're required that they give you a lawyer if you cannot afford one. They have to have a lawyer there if they're going to do anything.
Hold on. I went and saw a public defender, and it.
So they're lining you up to get thrown in. That's what they're doing.
It went really weird, and I asked if I could record, and they asked me to leave, and yeah. So that is not a good.
I would suggest.
He said I was guilty. I did it intentionally, and I was like, "Sir, I didn't." And he's like, "I've been in front of this judge a lot of times. And then I was like, I thought you were a public defender. Do you mind if I record this? Because I was like starting to realize it wasn't going well there either.
So you have defense attorneys that they're giving you that are working against you at this point, is what you're telling us.
Exactly.
They're looking to get you to throw you in jail. They're going to throw you in jail for 30 days. You know, that's what it sounds like to me. I think Jill's 100% right. If it were me, I would not go forward with that lawyer
Well, so
tomorrow.
I'm scared to go to court because of that. I mean,
you need a lawyer that you're going to be comfortable with. If you're not comfortable with that public defender, you're going to stand up right away and say that I am not comfortable with this person.
Yeah, I mean, I am.
But here's the thing: if it were me, I would say I had a conversation with the public defender, and they said that they know the judge, and there's I think you think there's a conflict of interest here.
Well, I mean, he did say,
and it's going to be a 90-day jail. I would. Do you have any medical issues? Do you have any acute?
For some reason, I'm thinking this contempt was 5 days in jail, but that's the other part of this. Some people said this was Miss Mamani's contempt against me, and that the judge dismissed the one he did against me. I mean,
wait, stop. Why were you at a public? You don't even understand the nature of the proceedings against you. It's tomorrow, and what I'm hearing is you don't know what's going to happen tomorrow. And you saw a public defender the other day. The only way you see a public defender is if there's a potential for you to go to jail. So I would tell the judge immediately, I don't understand the nature of these proceedings against me. I have counsel that I don't trust because they know you and they're conflicted and I have no relationship. And so you want new counsel that can explain things to you and understand the proceedings, because they can't throw you in jail if you don't understand.
And that's what I was going to say.
They can't go ahead with the proceedings. You don't understand what's going on.
Can I ask for that though tomorrow?
Yes, of course you can ask for it. It's the first thing you should ask for. It's America, goddammit.
I know. I'm just, you got to understand how scared I am. I mean, I'm intimidated.
With very good reason. Richard, can you advise her in terms of getting?
I'm not advising anything. I'm telling what I would do in our circumstance. I'm saying that this is America, and if I was going into a court and I didn't know what was going on, and I had a public pretender that didn't tell me what was going on, and says they know the judge and then said that you're guilty to you beforehand, then I would say this is not my public pretender. I want either another lawyer, or I either want, and I want to know what's going on with this case. I want somebody who can explain to me procedurally where I stand. I don't know what this case is all about. That's what I would say.
That's what my plan is. But I'm worried about my attorney too, because
listen,
she'll
be fine at the end of the day. You don't have to worry about you. You're the one whose ass is going to be in jail. And you're the one that doesn't have, she has the benefit of having gone to law school, and she knows what to expect. You have no idea what to expect. She's not your attorney. She's not your attorney on this case. Yeah, she has an attorney. She's not your attorney on this case. You have no attorney on this case.
I know.
You need to get yourself a lawyer, and one that you can trust. That's the problem here. You've got a lawyer you can trust at this point.
Okay, but the other problem is that any attorney who has a license in that state has an allegiance to the court and not to the client. So you are not represented, and you are not going to be represented by anybody in that community that has a license. And there are things that need to be done, but you need to get a continuance in this case.
I agree.
Do you have any medical conditions that would impair you?
Well, I mean, I did get a full diagnosis of PTSD. I mean, I do have that severely.
Preclude you from being in court tomorrow, that you would be so ill this evening that you would have to go to a hospital and be admitted.
Yeah, no, I'm a really healthy girl. So, I mean, thankfully I am healthy, but I am struggling with the fear. I mean,
but you're in so much stress at the moment that
I'm pretty concerned. Yeah, I mean, I'm scared to death, of course.
Your health could be compromised tonight to the point that you might be hospitalized.
Yeah.
And that would prevent you from going to the court tomorrow.
You have to be safe first and foremost. You have to be safe, and you have to, if a doctor says that you're not healthy, then that trumps everything. Right. You have to go, and if you go into the court, you have to know what's going on. So you have to,
I know.
So if I were you, I would look to your health first, and then if your health is okay, rights are.
That's part
You
of
know?
it. That's part of this too. The whole court the whole court proceedings. I really didn't understand a lot of things. I was just, and I told them I have a health and science degree, but I'm just not educated on this. And it with
the immediate
the
turn is tomorrow, and buying yourself some
yeah,
time to get
I will.
proper representation.
That's what you
Okay.
need. I think that's what you need to do. If it were me, that's what I would do.
You are
But that
Thank
walking
you
we've been,
both.
so we've been on almost an hour about
I
now. So
know you guys are
I want to wrap.
awesome.
I want to wrap up by just going over this now, because I want to look at the big picture, and
Sure.
the big picture is this. Jill, if someone's watching this right now, this whole idea that I have a court, I have my children taken from me, they're vilifying me, they want to charge me with contempt, I'm worried about going to jail. If there's somebody out there that says this sounds familiar, what should they do?
They should contact the Foundation for Child Victims of the Family Courts, and seek engagement with us for their evaluation of the case, to see what kind of legal remedies and interventions are necessary. These cases need to be litigated and prosecuted, and every
Yeah.
court actor involved needs to be evaluated in terms of their role as a participant in a racketeering scheme. And you
Okay.
need to look at the back channel.
I will agree. That's why I'm so scared. This is just so much bigger than anything I can really. I mean,
You've done a magnificent job. I mean, I think you have been absolutely heroic.
I just know I'm a good person and I tell the truth, and that I know this isn't right.
And totally, I mean, one can't say you're naive, because this situation is beyond comprehension. It has started in the early 1980s with the advent of Gardner. The courts were not like this before Gardner. Judges took off their black robes and talked to children and met with them in their courtrooms and
Well, so remember something very cool in this. I have a 17-year-old daughter. I've been a mom for 17 years. I've never once had a single concern in my parenting. She just graduated high school and she went through all of this with me. So, I mean, that just shows you how two kids went this way, and then, oh, here's my 17-year-old daughter who I've had her entire life. And
So I want to finish with this. I'm going to let you both answer. I'm going to say Jill first, and then I'm going to have Sarah second. And I just want 30 seconds. It's a very simple question. Is this family court system fixable, or is it fundamentally broken? Jill?
It is not only fundamentally, it is not broken. It is built. It is structured to be a child trafficking criminal enterprise. They know exactly what they're doing, and this is a protocol for action. Discrediting the protective parent, moving the children, and figuring out the cash flow from as many possible directions as possible. They know exactly what they're doing. Every single actor has its role and coordination, and nobody can feign ignorance or innocence of it. They're all working together in one portion or another.
Same question to you, Sarah. Do you think this system is fixable, or do you think it's fundamentally broken?
well, I know this, that, just to absorb what was happening to me is so difficult. It's still hard to kind of process. So yeah, I would say it's not a logical system. It doesn't make any kind of sense. And so it's going to harm you each time you go.
Right.
And it's very dangerous because just anything in silence or kept sealed or quiet. They tried to even hide my domestic violence expert witnesses. They wouldn't let me have people. They used my childhood abuser. I mean, they do all these really weird things that it's like, it's a very warped system. I mean, it's the scariest thing I've ever been through, and I'm 47
May I
years
say
old.
one more thing? There's a larger agenda. We are destroying 8 generations of children now. If you take 10 years as a generation. We are dealing with destruction of 8 generations of children. And there is a logic and a method behind it. It is counterintuitive to be in a democratic society and have this dark underbelly, undermining families and generations of children. So there is an intelligence that is driving this, and that's
All right.
the subject of another.
So we're going to close. I'd like to thank both of you,
Thank
Sarah
you.
Wolfe and Jill
I
Jones
appreciate
Soderman,
you guys.
for joining us. Now, this case is far from over. We'll have an
Right.
update after court. Tomorrow, March 31st, is the next chapter. A lot of
Yeah.
people will be watching. This is some huge issues about due process, about accountability, and whether this system protects children or protects itself. And so, Sarah and Jill, thank you so much for being
Thank
here.
you so much.
And for everyone watching, please stay informed, stay engaged, don't look away, and we'll be back with more information about the family courts.
Thank you so much. Have a good day. Bye.